These Inner Temple Movers and Returners podcasts are part of a profession-wide effort to retain talent and support the progression of all groups at the bar. Supporting career breaks and returners and those who are seeking to move between the practice areas is a vital way of encouraging diversity, equality and inclusion at the bar. You will hear from a range of hosts and various guests who will be sharing their experience, giving you opportunities and suggested guidance for all those seeking to move, return or manage their career break during practice. Hello, my name is Rachel Spearing KC, your host for the second part of our Moving and Returning podcast series. And in this episode, I'm joined by a panel who volunteer and mentor with Advocate. For more about who Advocate are, please go check out episode 1. But today, my guests are going to tell us more about the impact of their work and how this has benefited them and operated alongside their practice. So thank you very much, all of you, for joining us. I'm just going to invite you to introduce yourself to our listeners and explain a little about your practice and what your role has been with Advocate. Sophie.
Hi, so I'm Sophie Cartwright, King's Counsel. My areas of practice include inquest and inquiry work and public law work. I'm proud to be pro bono champion in Chambers for Advocate. I'm also the Greater Manchester Pro Bono Committee Chair. I also sit on the Attorney General's Pro Bono Committee, and I'm delighted to be part of this podcast today because I think that pro bono work should be almost part of every barrister's practice.
Thank you. Sarah.
Hello, I'm Sarah Lucy Cooper. I'm a specialist international family barrister. I've been a reviewer for Advocate for many years. In addition, I also mentor people on Advocate, and I do also take cases out for Advocate. Many of the cases I've had for Advocate have been extremely interesting.
And we're going to come back and learn more about that, I hope. Alex.
Hello, I'm Alex Findley. I'm a quite junior practitioner. I'm a tenant at Farrar's Building Chambers and have been since 2023. I have a mixed civil practice spanning employment, insurance and thanks to Advocate, a growing volume of chancery work. And I've volunteered quite extensively with Advocate.
And Alex, can I invite you to state your case for why people should consider doing pro bono work through Advocate? What have been the benefits both to you and others that you've experienced?
The first reason is somebody told me when I came to the bar that being a barrister was about being a vocational lawyer. And on pupillage, it's very easy to experience a narrow number of areas, particularly if you're a GDLer like myself, and then enter practice with large areas of law you might be very interested in, but have never practiced in. So I think the first reason is to sort of keep yourself learning in ways which maybe it will be hard to do, whether you're at a mixed civil set like mine in court, but on relatively small matters all the time, which may be fairly samey, particularly in employment. Or if you're a big commercial set, you might be fifth junior all the time and rarely able to get on your feet yourself. So, I mean, I know through Advocate I've done company law, which I wouldn't otherwise probably have been exposed to. I've done franchise work, probate work, some trust work, a couple of other claims involving fraud by directors, and some more complicated employment claims than would usually come my way, involving, for example, modern slavery or higher value discrimination claims. And I'm aware that, for example, colleagues of mine who are interested in inquests but hadn't done them have done, multi-day, I believe even multi-week inquests through Advocate. So it's a wonderful way to learn new areas of practice you are interested in but maybe won't get a chance to do for a while or aren't going to get a chance to do at all. I think the second reason is it's great for your advocacy experience. I've been out in the High Court on my own against a silk on an Advocate case. I've been in the EAT and I've done 2 multi-track probate trials, which are things that wouldn't generally come to a practitioner of my level, which is a wonderful way to get experience. And I think perhaps less so for people with my kind of practice, but I wonder if particularly you're at one of the larger commercial sets, you might be listening to this and thinking, well, I've done lots of areas of law, so I don't really feel I need to go and learn more black letter law. But I imagine your opportunities to get up in court are fairly limited. And it's really useful to be running a trial strategically and managing a client relationship on your own, I think, for your learning as well. The third reason is the warm fuzzy reason, which is that, we're in a system where the CPR is very complicated. A number of litigants who may have good cases get completely bogged down in the process and they don't know what to do, and they can't afford even high street legal help. And in amongst that, there may be a good claim, and finding it and making it work, or if they've launched a bad claim and trapped themselves in something that really they shouldn't have started, digging them out of that is quite a rewarding feeling. So yes, those are I think there are three reasons to do it.
And the CPR being the civil procedure rules, yeah, civil procedure, which can be quite complex for a litigant in person to navigate and understand what they should be doing.
Indeed, there are lots of litigants in person who I think expect that they will just thrust the facts of their case before the court and the judge will take an inquisitorial role and sort the whole thing out. And of course, the judge is not going to take the role of just descending from on high and getting between the parties and deciding who's the goodie and who's the baddie. And sometimes when that's what litigants expect, they can really tie themselves in knots with procedure, and it's very helpful to them to get them out of that.
And Sarah, can I ask you to give us a feel for your experience and state the case for what your benefits, both for you personally and to those that you've supported through your work with Advocate, have been?
Yes, I think I would start off with the benefits to the people that I have supported, because the nature of the work that I do, namely family, it's very personal to people. So perhaps I'm fortunate, because if you do take a family pro bono case, you are likely to see immediately what the benefits are to the person that you are helping. There are many family cases where people may well feel that ultimately the involvement or not of a lawyer may not have affected the outcome of the order, but what it will have affected is the experience of that person within those court proceedings, because particularly in family proceedings, people may emotionally feel extremely vulnerable. So having somebody speak on their behalf, that little act of kindness in itself cannot be overestimated as to how important it would be to a person just to know that someone else is there with them and is speaking for them. In terms of the professional impact on me, well, you have the opportunity to be involved in fascinating cases. I've recently conducted a 7-day hearing in the High Court. That case was before a full-time High Court judge. I had not one but two opponents, one of whom was a silk. The case was reported. If anyone is considering making any applications, whether it be to sit or for silk or for some other position, then of course that's very useful ballast for any application form. So all in all, I can thoroughly commend it.
And Sophie, can you tell us a little bit more about your experiences, perhaps looking at your regional experience and your casework, advisory roles and those areas you've already talked about?
Of course. So I think the first thing to say is that pro bono is not a substitute for legal aid, but the reality is the cuts in legal aid have meant that there is a huge demand for advice and representation, particularly in Manchester, in seeing firsthand with the charitable sectors or the advice centre. The acuity of need for proper representation is staggering. People that don't even manage to get through the triage where they're in desperate need. So the first thing I would say is that I really genuinely believe that doing pro bono work should be part of being a barrister. It should be part of what you have to tick to say you've done as part of your continuing professional development. There's the annual pro bono recognition list that's published each year. And this year, of those just short of 5,000 individuals recognised, only 642 were barristers. And there are now 18,000 practising barristers. Now, I appreciate that there'd be a huge number of barristers doing pro bono work that didn't seek to be recognised through the Advocate Pro Bono recognition list. But to me, those numbers alone show that we can be doing more across the sectors. You've now heard 2 specialist areas where people are practising. The work I've done principally for Advocate has been in the area of inquest work or judicial reviews from inquest. And it's staggering in this day where judges are supposed to have the judgecraft to be able to advise litigants in persons and assist them to have full participation. I've had a successful judicial review for a father whose child had died, where when I listened to the 1 hour inquest proceeding into his child's death and how he was treated, it was quite staggering. And you would think that judges and coroners are managing those cases for litigants in person. That's just one example where a father whose child has died, when there's been state agent involvement, would have expected a proper hearing. In inquest work, most of the advocate work that comes my way where they ask for my involvement relates to deaths where it's mental health predominantly, where individuals, patients have not been supported to get the proper assessment of risk. Unfortunately, very often they die, and it may not be an Article 2 inquest because it doesn't reach the threshold, so there's no legal aid. But nonetheless, serious state failings where individuals have died and families don't have the support of legal advice. So really, pro bono has the ability to make a real difference to people in extremis, having the worst possible family experience where really barristers should be signing up to advocate, offering their skills and doing this work, because still now there's so many cases, inquests for example, where families just turn up alone and don't get the answers that they are entitled to. So that is perhaps just a summary of my snapshot.
And you've mentioned that we know that the Attorney General's list is something that you have a connection with, the Attorney General's panel review, and many seek to join those GDL groups, and it can often be difficult to understand or to know how you can gain competencies or list your expertise to gain access to that. Is that something else which can help movers or returners insofar as their own experiences and developing their skill?
Absolutely. So the first thing, if you take on a pro bono case, judges go out of their way to thank you for doing those cases. They appreciate that essentially you are really showing your commitment to the public interest, and also they then will go out of their way to accommodate you potentially for listing, but also acknowledge the work you did. And so even if people aren't just doing it from the warmth or the requirement of just to do it because it's part of being a barrister, it does enable you to demonstrate competencies in categories that are necessary for applications, whether it's for silk or for judicial appointment, where you are identifying that you understand and appreciate issues of ethics, diversity. And it is one of the categories now that is looked at on applications. So even if you are not doing it because you want to help the public good, if you do it, you get the added bonus if it will definitely be something that you can rely upon to support applications. And I know in Manchester, where I chair the Greater Manchester Pro Bono Committee, for example, all of the leadership judges are supportive of the pro bono work and say that if you do this work, we will support, we'll give references. So again, it's something to bear in mind that you can feel confident after a case is finished to perhaps say at that stage, if you're considering an application, perhaps send the email to the judge at that point, draw to their attention you've acted in a pro bono capacity, and ask if in due course they'd support you in an application. I'm absolutely confident you will have 100% support in that.
And Sarah, you mentioned that you also act as a mentor. We heard in episode 1 a little bit about the volunteers who are experienced with advocate, but also are experienced advocates themselves in the respective areas. Can you give me an example of how that has operated when you've received a request to mentor someone and what that looks like?
Yes, I very much enjoy being a mentor, actually. I would say it was some way of a combination of being a pupil supervisor and also the Bar Council Ethics Hotline. What happens in reality is you give your email and your phone number to the person who wishes to have that support, and then you talk through things. They can send you their documents, you can comment on their written documents, you can give them a heads up on the practicalities. all of those things. It's a very fluid relationship. It's quite nice to be able to mentor people, and I would hope that some of the people I have mentored also feel that they've learnt something in the process. Some of the cases that I've mentored people on have been quite niche. They have been sort of some quite knotty issues around international family law, and that I suspect junior barristers would not have encountered at that point in their career otherwise.
So it can give the practitioner confidence that they are going to have some support and guidance in their decision making or judgment or advisory work, and then a hand holding when those challenges, perhaps with the court experiences or the preparatory issues in responding to skeleton arguments or preparatory directions, might be received by the person.
Absolutely. I mean, I've basically, edited people's skeleton arguments and position statements. I think that's quite normal. Just sort of make sure people are all going in the right direction. I would very much agree with what Sophie has just said about the joy of being an advocate in court when you are pro bono, because, and I say this as somebody who also sits part-time as a family judge, we are really grateful. So whichever side of the bench I'm on, if I have a pro bono advocate before me, or I am the pro bono advocate, there is a completely different dynamic. So yes, that's something nice about doing that sort of advocacy as well.
I can echo that from my own experiences on both sides. And of course, what Sophie was just saying about judicial referees can also extend to your mentor if you are looking to establish a relationship with somebody that might be outside of chambers, whether that's to gain a colleague's perspective of your application to move chambers, or to speak of your work, the quality of that work, for other type of references, either associated with progression or other forms and applications that you might need, that person can also be utilised for that from the work you've exposed them to.
Definitely.
Alex, can you give me an example of where you've had to work with others because you spoke of your experience in outside of your barrister's work in Farrar, in new areas? Have you experienced mentors, and how has that enriched your practice?
Yes, I've worked with, I think, 6 different mentors on 6 different cases. I will spare their blushes and not name them all, but it's been really wonderful. Sometimes it's been as little as I think I've got the idea, but it's not my area, and so I just want to sense check it, or apply the bar ethics hotline test. Sometimes it's that I think in particular there was a franchise case that I took on that was really knotty, and I just didn't really know initially what the answer was, and I had a great conversation with a mentor from Radcliffe Chambers who pointed me to where the answer would be and set me out. So you can learn a lot. You can work with silks who are outside of your practice area as well, which is even if it's not they tell you, well, you should look at this, you just learn a lot by seeing how they think through the issues in a case as well. So from a learning perspective, it's been great. It is nice for building relationships with people across the bar. And I'd also say I've been co-counselled twice, which is where I've agreed to assist a more senior barrister on something, not quite as junioring, but we've done different bits of the case together. And that's been, again, a really great learning experience, and something I would say if people are worried about doing it, the mentoring is extremely supportive, but also the opportunity to perhaps team up with someone else and do a case that's outside of your comfort zone should provide most people with reassurance about that if that's something they're worried about. I've had a great time with it.
And we heard in episode 1 about a step-by-step approach, incrementally, to manage the case with the caseworker. Is that something which allows you to retain control or time management demands?
I think not just with the caseworker, but with the client, you can be clear about, I'll write your particulars of claim, for example, and then we'll see, I may or may not be able to do the next bit. So you can commit to work in stages. And I think the way I work with advocate is we might agree that perhaps we would look at going all the way to trial, but we'll authorise work bit by bit, or perhaps they will authorise it to trial, but I will nonetheless be able to say this is not something I can do.
And how are cases managed alongside your professional practice?
So there is an opportunity when you do work through advocate to get solicitors involved. The sort of referral where you're just doing it from the caseworker. But there's also Pro Bono Connect. So if you're doing a case for advocate and it needs a solicitor, I've had it many occasions, they then put it out through Pro Bono Connect and solicitors will come forward. So you're not then doing it just with advocate. You can have the support of a solicitor, and almost on every one of the bigger cases I've done, either through Pro Bono Connect or solicitors I know that do this sort of work, they will then step up and volunteer to do it as well. And the thing I would say perhaps as well is when I've done some inquest work, it's sometimes been really significant city firms in London that don't do that area of work, but as part of their ethical work from a good conscience perspective, they step up to offer support, and particularly on judicial reviews. And you can literally have a city red carpet service where they're doing translation services, because there's that goodwill within the solicitor profession. So I wouldn't want people listening to this to think, well, if you're doing pro bono work, you don't have the ability to get a solicitor involved. Pro Bono Connect, if you think you needed a solicitor, you could say that to the caseworker. They'll then advertise it through Pro Bono Connect, and you may then find out that advocates slip away, but you then are continuing to act pro bono with the solicitor that they've sourced through Pro Bono Connect.
And we also heard in episode 1 a little from the casework management that they advocate offer and do support the liaison between the layperson, the litigant, and the barrister, as and where and when that is also needed. They can offer that support.
No, they're really good, and particularly so in the early days, if you're having a meeting, from the perspective of, I'd want a caseworker there, because then they're taking a note, they're present as well as you consider next steps and what's needed, particularly if the initial advice is quite limited. So again, that you're then tasking the caseworker to do additional steps, which could be liaising directly, for example, in the cases I do, with the coroner's office, getting the disclosure. So it's not just a one-way street. You work collaboratively with the caseworker, but also can step it up to the next level with getting solicitors from private practice involved on a case-by-case basis.
Sarah, do you want to add something?
Once again, I want to very much agree with what Sophie has just said. In fact, in the High Court case I did, what I did was I did get a solicitor involved. That was obviously very helpful to me because it meant I was no longer acting direct access, which would have been tough on a 7-day case. But what it also did was it gave me an opportunity to show my advocacy in front of an extremely good solicitor. So that's something else to bear in mind from a professional development point of view.
Alex?
And actually specifically, I've worked with Charles Russell Speechlys and Vile Gottschall and Manges, just confirming what you said, Sophie, that you can work with some firms who are really very prestigious city firms through Pro Bono Connect that you might not otherwise get to meet, and that is both great networking and can hugely smooth the process of case management and preparation.
And Alex, can you give us a flavour of how junior or less experienced practitioners may sometimes feel they'd benefit from guidance before taking on a case? How does that operate in reality when you look down that list?
In reality, every case has a review, so you can read the review and then read the papers and then get a sense of whether the issues are something you might be able to stomach. Generally, I've taken on cases and sometimes you'll get in there and actually it's only once you've done a bit more research you hit a wall and you think this is a little bit further outside my comfort zone than I thought, and that's normally when I would say I'd quite like a mentor on this case. I'd speak to a caseworker, we'd probably have a discussion by email about the issues, and then they'll put out a mentoring request. I'm not sure quite what the process is for that, and then the mentor will get in touch. Generally, as Sarah said, mentors are really available by phone and will probably have several conversations about what to do, and perhaps if I'm stuck with what preparation steps to take, they can be very hands-on in saying, well, first you should research this, then you should draft this, then you should send this letter, and then we'll come back and see. There can be a lot of hand-holding, I think, for junior practitioners who are worried that they would just be dropped in at the deep end without any support at all.
And Sarah, you've been one of those reviewers. I think you mentioned in your introduction as part of your work with Advocate. How do you review cases, and what does that look like for someone who's wondering how the allocation or their experience might be matched?
In relation to reviewing family cases, unfortunately, we have to adopt a very draconian method because the volume of family cases that comes in is so high. So really what we're looking out for is something that takes what possibly is a relatively simple case out of the ordinary, such that we can ask volunteers to volunteer to represent. The sorts of issues might either be a knotty legal problem, or it could be something rather more practical, such as the litigant is not a native English speaker, or for some other reason cannot manage the documents, they don't read, they may have some sort of disability, there may be all sorts of vulnerabilities there. And those would also be the soft skills that it's very useful to acquire as an advocate, particularly if you're an advocate doing family cases. So it is highly likely, if you take a family case, that there will be something special about it, precisely because that is the methodology we have to employ when we're reviewing which cases will be advertised to the volunteers.
Obviously, on triaging at the moment, sometimes what was described as a draconian approach has to be taken. And that's because the pool of advocates signed up to Advocate is not there. If the pool of volunteers was greater, then the triaging would be different. So again, if anyone's thinking about doing pro bono work, sign up with Advocate. You'll then be offered these cases. And if there is essentially the pool's bigger, then more cases can be taken up. So I really would encourage everyone to sign up. But additionally, just building on the mentoring, it's a huge privilege to be mentored. And that mentoring is there. And it's great for people returning to work, people wanting to just try a new piece of work. And I can guarantee that Advocate can help if anyone's not feeling particularly confident or there's an issue on a case that they just want to sense check. Advocate will be able to find someone that will able to be that source of support. And I've done it many times, and it's a huge privilege. I mean, to me, it's part of what this career is all about. Being a barrister is supporting other barristers. And so I'd encourage people thinking as well that, how can I do this if I'm not sure about something? You will find the collegiateness goes across circuits and across chambers. So please know that the support will be there through Advocate.
We also heard, Sophie, that there are almost daily cause lists, and one of the challenges for people who are managing a career break is that there may be work that they want to do or can do whilst they are on their break. It could be with paper, or it could be mentoring others because they've got that experience and they can have those conversations. So it's not just going to court, although going to court is something that they very much could be able to do. It sounds like there is a lot of other roles and a lot of other benefits that a practitioner who is moving, returning, or might be managing their career break at that time can give.
Absolutely. And Advocate schemes cover almost from the start with the pupil pledge, where a pupil can say that they're going to do one piece of work in the first 6 months, right through to senior barristers either doing the cases or supporting in a mentoring role. And it's not just about doing the court work. It could be some urgent paperwork, advisory work, or it could just be simply giving provisional advice on a specific issue. So it's not always cases in court, although they are there. But to get access to those and what's needed, you just need to sign up, because then Advocate publish where the work is, what's needed, and that's your opportunity to say, actually, that case is a fit for me. And the more you do, the more you'll be offered, because in reality, if you're then known to the caseworkers, if there is a case that is perhaps more high profile or is a case where it's going to end up in court hearing, then there's that opportunity then. If they know you and know that you're dedicated to the work, you're more likely to be offered what might be considered the better quality work, or work that actually might equally end up, for example, an inquest. If it's good, it could be Article 2. There might end up being funded legal representation. So you might start off doing it pro bono, but it could actually lead to funded legal representation through a scheme that the litigant in person may never have an ability to access without representation.
I'll just add to that for anyone who is junior and who is worried about taking on a case, I've done, I think, about 25 cases, maybe 400 hours of work, and I've never once fallen into a case and thought, I'm trapped in something and there's no one who can help me and there's no way out of it. It's never once happened. And I don't think it will.
So, Sophie, although you're operating in a pro bono space, are there some cases where you can consider recovery of costs on behalf of your client that you're representing?
If you're appearing in a jurisdiction where there's an ability, if you're successful, to make a cost claim and application, the court can make a pro bono costs award, and that then means that essentially what would have been your fee for acting can become the equivalent cost award that will go to the Access to Justice Foundation, and that then money is going back into the charities that are providing pro bono advice. And I know Sam Hill as King's Counsel, who acted on a family case, I think got one of the most substantial pro bono costs award, tens of thousands of pounds, which made the most substantial difference to what Advocate could actually do as a result of the pro bono costs award that she was successful in achieving, having acted in a family case. So it's another thing, if you practice in areas where costs are recoverable and you do this work, the giving of your time free, pro bono, could then translate to the cost of what your fees would be when acting privately, going directly to the charities that do this work. So another reason to consider doing pro bono work.
Well, I'd like to thank all of my guests for joining me on this podcast. Sophie, Sarah and Alex, thank you very, very much. You can find a range of helpful information to support practitioners who might be considering, planning or managing a move, return or break in their practice on the Movers and Returners section of the Inner Temple website. You can also find some of the resources mentioned in today's episode within the podcast description. Thanks for listening.